Hi.
Hi, Lauren. How are you?
Doing well. How are you?
Doing very good. I actually had to step out of my office because the Wi-Fi in my office actually slows down TikTok. So I'm actually at a little food court, which is great. It's a great environment, a little bit of energy here. It's great we could do this, even if we got like one watcher at the very least. I'm very curious about your trial and your experiences. I'm sure I can learn a lot from you.
I'm sure I can learn a lot from you.
What kind of area of law is it? Personal injury or criminal?
Yeah, so I do all personal injury litigation in North and South Carolina.
Is that actually an area that you were hoping to gear it to when you were in law school?
Absolutely not. No.
Really?
I wanted to do entertainment, sports law, NASCAR, stuff like that. Absolutely.
NASCAR.
Yeah, I mean, I'm from Charlotte, so it's kind
Okay,
of,
yeah.
no, entertainment, sport, NASCAR. That's what I wanted to do. And then I realized that it's so boring and it's not what I want to do. It's content. I was like, no, I want to be in the courtroom. So yeah, that figured out pretty quickly. I wanted to be in a courtroom.
And a lot of transactional attorneys don't always get to see the courtroom.
They never see the courtroom.
Unless they get dragged in or something. Paralegals don't see the courtrooms. So a little bit about my background is I work in international law. So I do see the courtroom a lot, but it's international cases. This one that's coming up, we're representing the government of Denmark, where there were some investors that defrauded the government. And so they're suing in New York District Court to regain that money from fraud. But they could be a little bit larger clients, which are harder to deal with because they're not always available. And there might be documents that might be beyond my scope. So we have to work with our experts and witnesses to understand what we're looking at.
And you're on the East Coast, so you'll be on the East Coast for that.
I'm actually in DC.
Oh, okay.
Yeah,
Right.
yeah. So the trial would be in New York.
Got it. Well, my co-counsel that I just got out of this trial with, he practices in New York also. So it was like a fish out of water for him because he's Crohack Vice counsel and I was local counsel in North Carolina for this New York firm.
How did you then? It's just curious because if you're starting off with transactional, the personal injury just kind of happened because of internship or summer associateship or something like that?
Absolutely. So between first and second year of law school, I interned for NASCAR and I loved it.
Oh, wow.
I didn't want to sit behind a desk and
Okay.
write the contracts that govern all those stickers that are on all the race cars. So I decided to intern at an insurance defense firm between second and third year. And I loved that part. And I accepted a job right out of law school, but I quickly learned I did not like representing insurance companies. And I was miserable and I didn't like turning off people's benefits it was just sad. I thought what I did was bad. So I noticed that a lot of plaintiffs lawyers were their jobs were harder, a little happier because they help people. So I was like, that's what I want to do.
Okay. Do you get to interact with clients often when you're in your role?
Oh, absolutely. I talk to every client. We don't sign up a client unless I've spoken with them and I know that it's a case that I believe in. So my paralegal and I vet every single client in every single case.
That's great. I think every law firm is a little bit different. They might have their paralegal do most of the grunt work or intake. And in other cases, there might be an associate and then the partner may take over when it's the oral arguments phase or something like that.
Yeah, my paralegal has been with me for over 13 years, together for 14 years now. And so she might talk to someone first and think, hey, I really like this case. I've set up a time for you to talk to them. That's usually what we do. So that's the way we handle it. And it worked really well. She's like the other half of my brain.
So tell me then, you got into a 5-week trial, just kind of starting out with that. Why would it take that long in a personal injury case? Is it complexity? Are there multiple plaintiffs, defendants? What's going on with this case?
So in North Carolina, we have extensive voir dire and the lawyers get to do voir dire and it happened in the courtroom. I know in states like New York, we took a jury in the basement with judges involved. And then it's not an extensive jury selection process. But this was a medical malpractice wrongful death case. So number one, it's a very serious case. Number two, we're in a community where people might have strong feelings and might be connected to the medical field. So you have to work through a lot of those things to make sure you have a truly unbiased jury. So jury selection will usually take 3 or 4 days in a case like that alone. In this case, it took 4.5 days to get a jury. We needed 12 jurors and then we needed 3 alternates.
That's amazing. I've never been through that process that took longer than 3 hours. So I'm sure every state does it differently.
Yeah, my co-counsel had never been through that before. So the way we divided up the case is I handled the pretrial motion and the jury selection. I handled all the lay witnesses. My co-counsel did the expert. I did the jury instructions and we split the closing.
Okay. That's a great structure.
Yeah. It was nice because this time I wasn't doing it all myself. Usually I'm doing it all by myself and it's me and my paralegal. But this time it was nice to have someone else to help carry the load and actually have a competent person to help you.
It was great to see some of your videos because you don't often see attorneys recording during trial. They'll maybe talk about it before and after, but never like the actual grunt work. So after every day, you were all going into a conference room and you're really working through it. You're working through the days and the notes. Maybe somebody's printing up the transcript if you have it or the draft transcript. What is that like every day? Do you expect every day to know, okay, here's what we're going to have to talk about for the next day, or are you sort of days ahead?
So we try to plan days ahead, but Beth laid plans. So that conference room is literally right outside the courtroom. And so that was our conference room and pretty much where we lived when we were not in the courtroom or, in our hotel rooms or in the hotel lobby working. We were in there with our clients. We would meet with experts in there. We were in there in the morning for an hour before court. There's a mid-morning break that we were in there for 15 or 20 minutes. We're in there during lunch for an hour and a half. And we're there for the afternoon break. And you probably saw us arguing over how to handle something. That happens a lot. How to approach things. We did.
And it's not a really large room.
No, it's tiny.
You get what you get.
Yeah, you get what you get. I think you can maybe sit 6 comfortably, but there was no circulation. That's what you couldn't see in that.
Right. There's no windows.
No.
So you're sitting in a dark room, a very small dark room, and you've got to talk to a lot of people and you've got your litigation bags, your documents. You're basically doing everything.
Yeah.
And I think a lot of law students or even attorneys who haven't been to trial have no idea that you're going to be uncomfortable during this trial.
Very uncomfortable. You have to learn to live in uncomfortable. And my aura ring thought I was working out the whole time. It's like, your heart rate is very elevated, but you can't show it. You have to sit there and just keep your composure. But you have all your freakouts in that conference room, and then you go back in and act like nothing has happened. But it's funny because when you started breaking down my court bag, I was like, wow, I guess I never really thought about that, but literally everything is in that bag.
Right.
I write down everything the witness says on a different legal pad. And by the time that trial was done, I think I had 8 legal pads.
A lot of times you don't get the benefit of going back to your office. It might not be close enough. So you have to take everything. Sometimes people pack snacks. They might pack some supplies, and not all courtrooms will provide a printer. So sometimes the team has to bring a printer if they think they're going to print. So yeah, you're living out of your suitcase and your bags for a while.
That's where my extra monitor is. It's an extra pair of shoes so I don't have to walk in heels. It's snacks, water bottle. I mean, literally everything. I took the tripod one day and it was funny because the security in the courthouse were like, what is this? Was this a weapon? I'm like, no, it's a tripod. It's okay.
That's funny. Yeah. And is it in your court in North Carolina, do they have to have an order to allow for electronics to get through?
No, you just can't record in the courtroom. There's usually just signs that say no using of your recording without judicial approval. So if someone wants to come in and record, they would need to get judicial approval for that. In some courthouses, lawyers can't even take their phones in the courthouse, or only lawyers can take their phones in. Because I think they realize now that, especially if you need to communicate with experts or your office, you need to be able to text someone that says, okay, someone can come in. In our case, the witnesses were sequestered, which doesn't always happen. But we would have to communicate with experts back at the hotel and say, okay, you can walk over to the courthouse now, but just don't come in the room.
So one of my last trials in New York, the judge did not allow for even the attorneys to have their cell phones. So we had to request a special order for the team to have their cell phones to communicate back and forth. Not only that, sometimes we need a document and we need a hotspot to be able to download it for hot seating or anything that might be coming around, to email things to the clerk.
Yes.
So there's that need, but I'm shocked that there's still courtrooms that don't allow for technology. Even checking monitors. If I was bringing a second monitor, I would get a look. It was like, is that part of the order? So I had to show them the order. Sometimes I would laminate it because if you're going in and out, you're always putting it in your bag. You have to laminate that order so that the security will look at it.
Well, what's interesting is a lot of North Carolina courtrooms are not technology courtrooms. So I always have to bring my own TV, my own 50-foot HDMI cable. I bring my iPad so I can attach the HDMI cable to the dongle to be able to cast your trial pad. So I do a lot of my own hot seating and displaying exhibits. But this was nice because this courtroom was a technology courtroom. So I would actually plug in my iPad directly to the court system and everyone could see it. It was actually kind of funny. My son always does something really funny before I go to court. I'll show it to you. I didn't realize that I had it plugged in. I thought it was in present mode in trial pad. And this is what appeared on it was absolutely ridiculous. It's fake. But it was such a nice moment of levity because the jurors, they were like, oh, that's so cute. I was completely mortified. I think my face was bright red, but it was hilarious. I told my son that afternoon, I was like, your face was all over the courtroom and the jury loved it.
Yeah. Or sometimes, depending on the judge, they might scold you for trying to win points with the jury, but that was completely unintentional.
I think the judge knew it because it had been so seamless the entire time. And then I plugged it in without being in present mode in trial pad and it just appeared.
So they use trial pad.
I do. I love trial pad. It's so seamless.
I thought it's really helpful. I used it for an international case and some people thought it was crazy because the other side had trial director and they had 3 different monitors. But trial pad was just easy. It seems more intuitive.
It is, and it's more plug and play. So you can use an iPhone and an iPad. I know a lot of defense firms use, what's it called? Oh, there's another one that's really popular right now. But I just think trial pad's easier. And for $600, it's kind of open to everyone.
Right, because you also get the deposition platform and I think it's an exhibit platform.
Absolutely.
They're helpful because after every day, I will get the trial transcript and upload it into that deposition feeder and I'll extract the highlights of the day.
Yes, we do that too. We get a daily unofficial draft transcript so that we know what happened, what we're doing for the next day. That's also really helpful. And considering this was a hung jury, it's especially helpful because now we got to do it all over again.
Oh, wow. So do you have a date for that?
We are going to be doing some discovery on some other matters. There's some post-trial hearing or motions that have to, and a hearing or two, but hopefully before the end of the year, fingers crossed.
When you got started in this field, were you surprised by how long it took from intake to trial?
Yes. Yeah. I think that was pretty frustrating. Even as a baby lawyer, I would get cases from my boss at the time, and it would be a case that happened 4 years prior. And like, go try this case. I'm like, I don't know anything about this case. Like, you'll probably lose. Just go try it. And I did. And, that's what builds character. But yeah, even a small auto case took forever to get all the way to trial, especially with COVID, because there's such backlog now.
Yes, I imagine the courts, even today, are very packed with their schedules.
Absolutely. Not a question.
So after every day then, you're just going back to the trial. Are you doing a full day of trial, like a 9 to 5? Or is it?
Our court day started at 9:30 usually. And then we would be done at 5. Sometimes we would push it to 5:15, 5:20. But, they don't want to do that. The courts are run by the counties. And so you're reliant on your county employees, your bailiffs, and things like that. So the judges are really respectful of everyone else's time. And we give
That's
everyone
great.
an hour and a half for lunch. So really, we tell people court days are so abbreviated. You pack so much into 9:30 to 12:30, and then from 2 o'clock to 5 o'clock. So really, you're having 6 hours and you build in 2 15-minute breaks. So it's really only a 5.5 hour court day. But the lawyers are working from 6 a.m. to 11 p.m.
Yes.
And sometimes if you have an expert on the stand, you might only get one witness done in one day.
So that's probably one of those things that most people out there don't know, is that these hours are long, but they're long for a reason. You're not just twiddling your thumbs. You're preparing for the witness, pre-witness prep, then during the witness cross-examinations, then maybe reviewing to see if some of the questions may have scored points or may have hurt you for the next witness and what you need to cover.
Yeah.
You give it a lot.
Witness was weak on one, expert was weak on one point. You have to hit it hard with your next expert, because maybe you don't need a second expert in a certain field. So
Right.
in these medical malpractice cases, you can have experts in 3 or 4 fields coming in to testify.
Have you had witnesses or experts dismissed or skipped as a result of what's going on?
We've chosen not to call experts. In this most recent trial, we wanted to call a rebuttal expert and it wasn't allowed. In retrospect, next time around, we'll call that witness in our case in chief instead of rebuttal.
Right.
So you live and you learn. But when you try a case one, you learn a lot and you know what you will do next time and what you need to double down on for the second time around, if there's a second time around.
I've been in situations where opposing counsel may have dropped somebody, in which case then we end up dropping somebody because they were a rebuttal.
Yeah.
And then
That
that
happens all the time with
changes.
scheduling.
So it changes. You have to be very flexible. And you can probably, depending on how large your team is, you probably end up disappointing somebody because they're like, oh, I worked so hard to get that witness prepared for days and then we're not calling them.
I mean, that happened to us. We spent 8 hours prepping a witness and then didn't call them. Or we spent 4 hours prepping for a cross of an expert, defense didn't call. And you just think about it, you're like, oh my gosh, it's like 15 hours that was wasted. What could we have spent that 15 hours doing instead of
Right.
sitting in a conference room and talking about this ad nauseum?
You were talking about the hours from 6 a.m. to maybe 11 p.m. You're just working all these hours. How do you manage that with your home life? Because especially being a mom, that's very difficult. You have family at home that are waiting for you to come home.
Yeah, when I was in a 5-week trial last year around this time, it was in a neighboring county. So I slept at home, I ate breakfast and dinner at home, and I would at least see my family. In this trial, it was 3 hours away from Charlotte. So I was living in a hotel and I only came home twice for about 36 hours. It was really hard. And 2 of my kids had birthdays during trial. So I felt terrible. But I FaceTime with them. I talk to them every day. The good thing is my husband is also a lawyer, but he does not litigate. So
Okay.
he kind of knows it. I mean, it did look like a bomb had gone off in my house when I got home, but it was survival at that point. My kids know what mommy does for a living and they know that I fight for people. And so I think they think that's kind of cool too. So at the same time, they get it. And it's hard though, because you interrupt talking to an expert in a corner of a hotel lobby. And you're like, hold on, I got to go FaceTime my family because I'm not going to miss this.
Yeah, no. And I think we definitely had to normalize that more because we need those breaks to check in with home. And something kids, I have an 11-year-old and an 8-year-old. And during trial, I will either record a message and send it to them so that at least they feel like they heard from me, or just call them right after trial, because you're getting to that point where after trial, and then when you're going to gear up for the night, you have that little pocket of breathing space. That might be the moment where you can call family just to check in or hello.
Do the lawyers you work with give you a lot of free time during trial?
Not really. And sometimes it can be one of those situations where I don't know what kind of free time I do have. So whenever I'm in New York, I'm literally almost sequestered I don't go out. I'm like near my laptop because any minute somebody needs, let's create a graphic for this next witness, or we need to update the closing slides. Because during the entire trial, we're trying to create closing slides so that we're not doing it all on the last day. So maybe notes, maybe great excerpts of the cross that were there from that day. And then we'll pretty it up on the last day. Yeah. So a lot of times it can be things like that. And of course, there may be things you may stipulate to with opposing counsel, in which case now we've got to update documents that we thought we were going to present. Maybe if they're binders. I personally don't like having to have binders, but that's
use binders too, because
most people like.
They still want something to hold in their hand. And if one side does it, both sides have to do it. If you don't, it'll look like someone's not doing what they're supposed to be doing.
And sometimes they have that argument that like, we want our witness to have the freedom to take a look at the entire document, not just the excerpt that you put on the screen, which makes sense. So sometimes we have to update those binders, and that can be a lot of work for that night.
When is your trial in New York starting?
Next week.
Oh, wow.
Yeah, but I've done this long. Sorry? Federal court.
Okay.
Federal court.
That's exciting.
Yeah. They're beautiful courts. Some of them are just very large. I've never been on a courtroom like on a 43rd floor, which is weird.
Yeah, where I was in Raleigh, North Carolina, in Wake County, in the civil courthouse, there's only 12 floors. And that's actually pretty large.
Really?
Yeah.
I had a trial in the Court of Appeals in Pennsylvania. It was a matter where I think we were suing for voter ID, an issue with voter ID, suing the state. It's just one large courtroom dedicated to that trial. So it's a very large, pretty different, especially with the technology.
Yeah.
Like what you can plug in. So sometimes you have to bring your own cables and you never know.
I learned the hard way during my 5-week long trial last year that a 25-foot long HDMI cable is not sufficient.
Oh, wow.
Next time, I'm not doing my own technology, though. I'm not going to do it. I'm going to hire Legal Wheels or someone to do it next time.
That's a great idea. I mean, if it helps you buy some time or sanity, that may be helpful.
I mean, that's what I'm going to do. But here in North Carolina, it's not as necessary. Plaintiff's lawyers like to think their client's money. So I'm not representing a corporation. I don't have unlimited funds. This is my money.
Right.
I'm fronting it for my co-counsel. And so we're trying to minimize the costs for our clients as much as possible.
At the end of every trial date, are you sitting down with the client to explain what happened? Because I assume they may have some questions.
Yeah, so we're sitting with them. In North Carolina, they sit at counsel table with us, which is also different from New York.
Yeah.
They've put money in the back.
In the back, yeah.
So we're constantly communicating with the client. So we're in constant communication, and usually after court, we'll go back to that room for about 30 minutes, break it all down, and then walk out together. So we'll have a walk out of the courtroom to our cars or wherever, and we're talking about it. And then we'll talk later that evening. So it's not uncommon to be FaceTiming with the client in the evening as well.
Well, that's useful because I'm sure they may not understand what's going on or how a witness that was being crossed in front of you may have been either good or bad for them.
And sometimes the way they view something as good, I view it as horrible.
It's a little bit difficult to explain because then you're actually explaining the technicalities of how they benefit legal arguments as opposed to just the feeling of the courtroom.
Or witnesses that I thought did horrible on the stand, jury after the fact. Oh, we really love this one. I'm like, how? They lied. What are you talking about? No. What are you saying? But sometimes you get brain damage as a lawyer and you forget to pull like on one new names.
I've always gotten the benefit of sitting at counsel's table as a hot seater. I get that benefit of watching the jury react because the attorney's here, will judge, the jury kind of in the middle. And of course, you get to see the faces of whether something's seen positive or not.
Yeah.
Do you have somebody who gives you notes or are you watching the jury as argument come made?
So if my co-counsel is doing the questioning, I always like to watch the jury, watch the witness, kind of a little bit of back and forth, see what's going on. I pass notes constantly. I think my co-counsel at one point during the trial laughed at my hand and was like, "Stop writing me notes. I'm done."
Are you using these like sticky ones?
Oh, absolutely.
Yeah. I use them regularly as opposed to a notepad now because I'm so used to it.
I started throwing them away too. And so, or he would just grab it and like crumble it up and throw it in the trash. I'm like, please not do that. That is important. Don't crumble it up. But it's interesting because sometimes, he's not watching the jury, or if I'm questioning someone, it's important for me to get that because I'm not watching the jury when I'm active when talking and having a conversation with a witness.
I usually will save all those notes. So one, because they're very confidential. You don't want them to go in the trash or somebody pick them up or something, especially if you're like, what is this guy talking about? At the end, we're just having a nice little board of all these great notes.
I would keep them. There was a few that I wrote. I think I said, land the plane. Like, you need to land the plane. And so I just started writing things like that. Instead of or I'd write out, here's the question I want you to ask. Or I'd just say, like, I need you to politely shut up. Like, land the plane.
Yeah, because sometimes you don't know how it sounds. I often find that lawyers will write out their entire script or their outline. And then the moment that they start speaking it out loud, they realize, like, this doesn't sound great. I need to go back. I always recommend the attorneys actually do some oral advocacy or practicing because it may sound differently once they start speaking it out.
Yeah, 100%. I always will write down bullet points of things I want to cover. That way I'm not, married to an outline or, an exact way to word something. And that way I feel like if you have an outline, a lot of younger lawyers like to do that because it gives them a sense of comfort because you haven't really found your own yet and you're not 100% comfortable. And that's fine, but you just can't be married to that outline. And even when I wrote outlines, I found myself not sticking to them. And it's just important. If you have an outline, you're not always listening.
That's right. For cross-examinations, do you use a second chair?
So the way that in this last case that my co-counsel and I handled it, I actually wrote out all the crossings for the expert. And he had a different approach. He had like a summary and like a roadmap of like important things from their depositions that he wanted to hit. And then I took that and I made a roadmap for their cross and how we could impeach them, but also do things that helped our case. So that's kind of how we balanced it in the last trial. I actually wrote it out because a lot of things were in North Carolina specific. So I wanted to make sure that all the work wasn't on one person. And it was always important to have more than one perspective on it. So that's really how we handled it. And then if he skipped something in my outline, I'd tell him immediately, like, hey, you forgot to ask this. You need to go back and clean it up. So,
right, because sometimes you're like setting up the question. So you need to follow that pattern.
Right.
Yeah.
And you sometimes forget that when you're in the moment and locked in with the witness and you're truly having a conversation, you might forget that.
So I've seen that many attorneys, at least when it comes to cross-examination, may be brilliant at it, and sometimes it may not be for them. And where I've seen that happen is when you have an outline, you have a lot of facts, but having a natural conversation, being able to listen and also think about the next question, it'd be really hard for some people.
That's the hardest thing to do. And I feel like if you don't know, it's even harder if you're not comfortable and you're in a stand. Like, I feel like the jury can see that. They can probably see it. But it's also harder, especially like in a medical malpractice case, if you don't know the medicine, you can get tripped up really easily. So you have to know the case inside and out, number one.
Right.
To even be able to do that.
And this is where attorneys are always learning. Like, it doesn't end at law school. You're learning the medical terms. If it's a construction case or somebody may have had an injury, Then now you're learning some of the construction procedures, what the rules might be, the zoning laws. There's so many different things as attorneys are consistently learning and absorbing information.
I feel like my paralegal and I are learning something new constantly in every case. All law school teaches you how to think like a lawyer. It doesn't teach you the actual specifics because each case will flow different.
And that's actually one of the reasons I got on TikTok is I was hearing so many great perspectives from lawyers, and you would hear how they do things and I'd take notes. I'd say, oh, that's an interesting way of doing things. One tip that I've been passing out to attorneys going to trial is sometimes I would bring an extra bag of luggage. I don't know, maybe we call it a mid-size, but a check-in bag. But the reason is, it's because I found out this might be an issue in DC or more offices where people don't like you carrying boxes into their lobbies. But if you bring a cart with boxes, they always ask you to go through the loading dock or through the back or some other place. But if you bring it in luggage, then they're a little bit more flexible. So you start learning some ways of saying, well, yeah, now I can put this whole luggage into the X-ray machine versus boxes some other way.
Point. I've never thought about doing it that way. We're just so used to taking banker boxes in with
Right. Yeah. And I could put like 2 or 3 banker boxes in this piece of luggage. That's one tip I've learned. I've also seen some of my female attorneys, anytime they're bringing in heels, they'll put it in a different bag as opposed to the flats that they're weighing into the courtroom. Once they're passed through the security, then they'll keep their heels on.
I do that too. I have little ballerina flats that I can wear if it's a long walk, but I'm 5 feet tall, so I am always wearing heels. If I'm not wearing heels, people aren't taking you seriously because I'm the same height as my 12-year-old son.
Now, remind me, did you say that you did the opening or someone else did the opening?
I wrote the opening and I did the PowerPoint, but my co-counsel gave it. And that was important in this last trial because the jury had only really heard from me for 4.5 days. And so I did the jury selection, and it was important for the jury to be able to hear my co-counsel before he questioned the first witness. So it's just a little bit of how we divided it up, but also it was important for them to be able to hear from my co-counsel before questioning the witness.
How do you decide for an opening how much factual information I want to provide versus emotional information?
So, a lot of this depends on your judge. In North Carolina, especially, the pretrial motions always govern kind of through the parameters, but we're never really getting into evidence that's in dispute. And in our last case, our judge did not let us put any evidence in our openings. Excuse me. The judge did not let us put any evidence in our opening or on the PowerPoint unless it was stipulated to. So usually the only thing that will go into the PowerPoint that is evidence is like a photo of someone if they're deceased, or we always put up photos of our experts so that they see, here's who you're going to hear from. We always like to do that. And I like to use visuals and not a ton of words in the opening. But in the closing, I like to remind them of what the jury's heard. So some of the excerpts from the testimony, but also I like to go over the jury instructions in close because that's important to me.
That's helpful.
So the opening I like to do as more a roadmap. Here's what you're going to hear, and we're limited. And so at that point, that's really the first time they're hearing about anything other than general concepts in the case, because they hear about some concepts during jury selection just to make sure they don't have some preconceived notion about this type of case. But other than that, it's really just our roadmap of where we see how our case is going to play out.
Okay. That's interesting. Do you do a mock opening amongst your colleagues?
So I think it depends on the case. I like to focus group every case. I always practice my opening multiple times. I practice it in the mirror. I record it. I watch it back multiple times. Great. So I can actually tell the judge, here's how long my opening is going to take. Because the judge is going to say, how long is your opening? how long is your closing? Because they'll like to, the
Right.
judge, if openings are going to take all morning, they don't want to split it up. They don't want to have, the one lawyer go in the morning and the other lawyer go in the afternoon. They like to do them back to back, maybe with a 15-minute break.
Right.
And so I think it's important that all lawyers record themselves. If you can do some type of, mock jury or focus group you're opening, I think that's always a great idea.
That's really great advice, because I've seen a lot of attorneys that make the mistake of not doing that, and then they trip up when they actually view the presentation. And that can make a big difference, especially when you're doing it in front of a jury. If you're doing it in front of a judge, that might be a little bit different. But in front of a jury, they don't know the case. They don't know legal technicalities. They really need an explanation.
And for me, it's more about having a conversation with them. This took me longer to realize. When I was first starting practicing as a baby lawyer, I like to use all my legal stuff in my opening. And now in my openings and closings, I find it's just important to talk to them as humans.
Right.
Unless you're explaining the law and going through the jury instructions, I think it's important just to use.
Yeah.
Sometimes it takes you longer in your career to realize, oh, I need to just speak normally and not like a lawyer in my opening and closing. And part of that depends on the case, right?
Right.
You have to tailor it to your case, to your jurisdiction, who your audience is. But I think a lot of it is just being a human, and that's what our jury expect.
And that's a really interesting thing that you say, because when you're going through law school, they're retraining how you think. And here you are thinking, okay, now I need to apply what I know. But now you have to go back and actually dumb it down for an audience who may not understand this. They may not know why one fact is relevant or why the medical history might be relevant in this case. So you're really setting up a lot so that they understand during the trial what this case is really about.
Absolutely. And it's important to give them the roadmap that here's why this is important. Here's why we're showing this to you. Here's why we're not giving you 8,000 pages of medical records, because all of these don't matter, only like 100. So I think it's important to level with your jury and explain to them why you're doing what we're doing. It also builds credibility.
It does. It's a lot of multitasking that you're doing, because you're going through an opening, you're going through your slides, you're watching the jury, you're trying to either go faster depending on your tone, what you emphasize. It really can be a lot of work, especially if you don't practice it. It can be a lot.
Especially if you don't believe in your case. I find that if you don't believe in your case and if you don't know what you're going to say, or if you don't know your case, it looks really bad when a lawyer's just up there reading and monotone.
Yeah.
Like, it looks like amateur hour, and that causes the jury to kind of zone out a little bit and not take you as seriously.
In your time, have you met with the opposing counsel where you're just like, how did they get through law school?
Not so much how do they get through law school, but how are their clients trusting them to do this? And to some extent, all lawyers have to start out somewhere. And we see that a lot with the defense firms, that they have to give their associates time to get their feet wet. And so I normally see it with the associates that get maybe not main witnesses in a case, or do the opening and then read it off. And you're like, oh gosh, this is so boring. The jury's zoned out. This is great for us. But it's tough, because you're like, oh, I was there as a baby lawyer. I was starting out too. Someone, and some people, for trial lawyers, either you have it or you don't. And I think you learn very quickly in this business whether you have that certain factor that allows you to be able to sit in front of a jury and be vulnerable with them and talk to them. And I always tell the jury, like, listen, this is the hardest part. Getting y'all to talk is literally the scariest part of what I do. That, and then when I ask you for money at the end, those are the two hardest parts of my job. Well, and I lied. The number one most nerve-wracking is when you hear they have a verdict and you're waiting for them to come in. That is hands down the most stressful. Second is asking for money, and then third is getting them to talk. Because there's nothing more scary for me than a jury pool who won't talk to me.
Right. And that is a talent. And at least with the law students that I've taught in the past, I'll let them know it's not the end of the world if you're not great at oral presentation, because there's so many different ways to be a great advocate. You can be a transactional attorney. You can be really great at research and writing. And so there's a lot of areas of law where your talent can do well. So just because you're shy in front of an audience or you can't connect with an audience, it's not the worst, because a lot of these cases are done as teams. But on the other end, I once was on a case with opposing counsel. The case was high profile enough where the client on that side wanted the chair of this very large firm to handle the case. And I thought, as the chair of the firm, very senior attorney, been practicing for 40, 50 years or something like that they would be great. And it felt like they were incredibly rusty. It just did not hit any points. It looked like they were reading the script a lot of times. They forgot the PowerPoint clicker. And so it can go the other way. You could be a baby attorney who just doesn't know how to present you, and you can get rusty.
Well, I've also seen older, more experienced litigators talk down to their staff in the courtroom, be it their tech person, their trial tech, or their paralegal or their associate. And I've been absolutely mortified for them. And I'm thinking, oh my goodness, number one, I would just never do that ever. And number two, I can't believe we did that in front of the judge and the jury. And then I think it's such an awful moment. And then the jury didn't even pick up on it. So, that's another thing that I see with some experienced lawyers. They can sometimes forget their place and talk down to others around them.
There was that viral video of the judge who was scolding the IT person. I don't know if you saw it.
I did see that. It was in Texas.
I think so.
Yes.
I think so. And I was surprised. But if you did something like that in front of a jury, you kind of lose your credibility there.
I don't see any judges in North Carolina acting like that. I mean, we are so thankful for our tech and our courtroom staff and our clerks. It's just that is kind of unfathomable to me. I thought that was a joke at first when I saw it.
And there were some attorneys who would write in and say, I think you should apologize.
They got in trouble.
And they got in trouble. It's crazy. There's a lot of wielding the power back there. So the last time, going towards the end, and you get a verdict. We waited 2 days. Sometimes you waited a couple of hours. How long did you have to wait?
Our jury went out on Thursday and they were charged Thursday morning. So I think we closed on Wednesday. The judge read the jury instructions on Thursday morning. They went out on Thursday before lunch. They were out all day Thursday, all day Friday. We moved during the evidence to reopen the evidence because of some things that were discovered that wasn't granted. And we filed some motions while the jury was deliberating. The judge let them go home over the weekend, came back on Monday, said that they were deadlocked. He read them what's called an Allen charge, which is your verdict has to be unanimous. So in North Carolina, you have to have a unanimous jury. It's not majority rule unless you say, we lose a couple jurors and we only have 10 left. We'll agree to all 10, but they all have to be unanimous. And on Wednesday afternoon, they came back for they're deadlocked and they were split 6-6.
Oh, wow. So now you got to do it all over again.
Yeah, that's what it looks like.
But at least you have the outlines ready.
There you go. But we're going to tweak it though. You're not going to do it the same way that you did it. You try the same case the same way, chances are you didn't learn anything.
Right. And you definitely learned something from this, especially working with your co-counsel.
Well, and we talked to the jurors. One just emailed me the other day and I talked to one on the phone. So it's really important to learn because what the jurors focus on is usually not what we think is the most important. And that was the case in the case. So you do learn something. I think your jurors are your best focus group.
That's great to hear. So they're able to give you feedback.
Oh, absolutely. And I rely heavily on my jurors. There are jurors that I still stay in contact with from cases before COVID who gave me invaluable feedback.
That's great. Is there any kind of examples of feedback that you can share?
Yeah. So when I was about 6 or 8 years ago, I was 8 years into my practice, someone said something to me in a focus group. And they were like, well, why do you have long blonde hair? And they were very awful about my appearance. And I was still very young then. And what was interesting is it made me change my appearance. I started wearing my hair back. I started not wearing heels. I wouldn't wear bright colors and I wouldn't wear jewelry. And I changed my appearance. Then I didn't feel like me. There were a couple of years where I really took something someone said and I was like, well, this is what I need to do. But then I didn't feel like myself. And then I think jurors pick up on that if you're not being yourself. So what I really learned from that is I'm never going to do that again. I'm not going to change myself for what a juror says. Can you change the way you present something or how you do something? Absolutely. But never, especially as a female, don't change the way you look because a juror said something to you or how you do.
Right, because the next juror might have the complete opposite impression. Damn. Are there any maybe inside tips that you've learned to find how to pick a juror or how to pick the one that you don't want?
If you just pay attention and you listen, if you actively listen, you can tell who is going to be not a fair juror for the case or might have preconceived notion that will affect their decision making, which is what we don't want. We want fair and unbiased jurors. And I think if you actively listen to folks, in my last trial, I spent one whole day talking to these jurors. And in North Carolina, we get challenges for cause, meaning there might be a reason they're not fair. And we remove the judge for cause to strike them, meaning the court does it, and we don't burn a strike. And we get, a certain preset number of strikes where we can strike any juror for any reason. On this last trial, I didn't strike any jurors on the first pass. And then it was because I listened to them. And if there was a reason they would not sit for this case or be a juror on this case, if there was a reason they would not be a good fit, I listened to them. And we handled those with motions for cause. And I didn't strike one juror on my first pass. So that was the first time I'd ever done that. And I think the hardest thing to do is get them talking and then actively listen and get them talking with one another.
That's great. Well, I know we're getting close to time. So what are your thoughts now that you have sort of this break? Are you doing anything fun with the family?
We immediately went on spring break. We went to the Outer Banks in North Carolina and full swing. And yesterday I was in a full day of news interviews on a very high profile case that I have. So that's what I did all day yesterday. And today I'm just trying to recover from not getting done the work that I should have done yesterday.
Good. Well, it's always nice to catch up with other people to hear about their experiences, but to also to hear about how people sort of debrief and catch up on life, because it's not easy. It's definitely, especially anyone who's going to trial, it's not easy. And even, I don't know about you, but even while you're in trial, there's still other cases going on and that need your attention. And so sometimes the paralegals might be bothering you about it. We have to send this motion or something.
Yeah, I was doing that a lot, sending out demands and doing things during trial. But the hardest part for me after being this trial was the reentry process, because you are only doing one thing for that long. And to come back and then be in full mom mode, have all the other things that you need to do, laundry, dishes, normal life stuff that you were not doing. That's the hardest part, because it's almost like sensory overload when you already need a break.
Yes, laundry is the big one. It's if I'm away for 4 weeks, I'll usually be sending out my dry cleaning to some service that might be nearby or having the hotel do it because you just don't have time. It's the only way to buy time.
It was very dependent on the hotel laundry as to what I was going to wear the next day.
Yeah. And do you have a favorite after trial drink to celebrate sort of the end?
Yeah, absolutely. I am a goose martini up and a little dirty with blue cheese olive.
That sounds like a great drink. I'm actually like, I don't know if there's a way to maybe switch. Oh yeah, there is. Because this is what my view is. This is a bar. We're in front here. So this is sort of the lobby of this building here. You're going to encourage me to grab a drink.
I mean, it's 5 o'clock somewhere.
That's
slightly dirty martini is the way I like to end a trial.
Yeah. Well, it's been a real pleasure to hear from you and see your TikToks from my actual real perspective. Because sometimes you hear a lot of attorneys talking about their work. I always feel like they're either conflicted or restricted as to what they can say. So seeing your behind the scenes work has been really helpful. And actually hearing some of your talks about what you do, because not everybody understands what personal injury might be about, what the billing might be like, with contingency fees. Like you're really paying for a lot after yourself and taking a huge risk on some of these cases.
Yeah, people don't get that. I think you just hear the pejorative terms, ambulance chaser and those things. And they're like, oh, well, I don't need a personal injury lawyer unless something bad happens to me, which is true. But there's a reason I don't gamble. I gamble all day for a living.
Well, I imagine that some people should also consult with a personal injury attorney on smaller things like maybe having somebody review your agreement before you sign up with an insurance company. Like, what are my minimums? So smaller stuff, just so I can avoid these issues later.
Well, it's funny because I'm like, those aren't sexy topics. No one wants to say, well, what are your insurance minimums? And do you and your husband have separate policy? No, we have combined policies because it's cheaper. Well, what if you're in a wreck? Then you don't get the benefit of multiple layers of coverage if you're hurt. And
we have uninsured motorist insurance.
I talk on those topics in North Carolina all the time with our state trial lawyer, but maybe I should do more of that on TikTok.
Those are great topics because you don't realize how you can save yourself the trouble. Some of these cases may go big because maybe there just wasn't the right coverage or insurance isn't covering what was signed on paper. It could be the smallest thing from a comma to you didn't sign something or pay maybe a premium on time and they can cancel your insurance. So many different things that can happen. And so it doesn't need to be to the point you're injured before they reach out to you.
Yeah. I mean, or they could reduce your UIM coverage and you don't even know it.
So maybe
another one of these.
Oh yeah, this is fun. I can ask questions forever.